it's our belief that we're not a proper party to this action. For this race, these candidates do not file nomination papers with our office. Correct. They simply file with the county clerk because it is a one county election, not a multiple county election. So pursuant to KRS 118-165, we would orderly move to dismiss as an improper party simply because we do not certify these candidates and they do not file their nomination papers with our office. I can provide a little more detail if you'd like, but none of the parties are agreeable to that. We went through the same thing in Rockcastle County last spring, and the parties seem to agree.
This is one of those situations, Your Honor, where we just named everybody. We didn't want to leave anybody out. If they're not an indispensable party, then certainly we have.
I don't feel that they are. They don't certify the candidates, and I'll sustain the motion to dismiss if you'll tender the order, and the Secretary of State's office is dismissed from this action.
Absolutely right. Thank you, Your Honor.
Yes, sir.
If I could be heard for just a moment.
Mr. True.
Guthrie True on behalf of Mr. Jones. Your Honor, when I got up this morning, I really didn't expect to be in the Spencer Circuit Court. I do represent Mr. Jones. I learned of the service of the petition yesterday late in the day, and sometime after the 5 o'clock hour, I learned about a hearing being scheduled today. I was out of town, in fact, at the time, traveling to and from a meeting yesterday evening with some clients. I didn't return back to Frankfort till about 10:30 last night, and frankly have been tied up in other matters this morning that were already scheduled that had to be taken care of. I barely had an opportunity to review the petition. I have had some opportunity to review it briefly. My understanding is that this is a petition filed by the candidate who lost in the May 2014 primary, and now we're a week before the general election, which she's not on the ballot for the general election, and is now contending for the first time that Mr. Jones is not qualified to be on the ballot. Understanding the ballots have been printed. I have had an opportunity to review briefly the statute under which the plaintiff is acting in this case. I think the statute does require that a motion to disqualify be filed prior to the election. It looks like that has been accomplished. The statute doesn't require the court to do anything else at this point in time.
That's correct.
Any remedy, if there should be one necessary, which the court can fashion, can be fashioned at any point in time. I think it does not have to be accomplished today. I do notice that the plaintiff has asked for some discovery. I don't know what Your Honor wants to do on that matter, but we would ask that this be set at a more appropriate time when there is some opportunity to have read the pleadings, to have responded to those pleadings, and to be prepared for a hearing in a more timely and appropriate fashion, particularly given the fact there's no need for any emergency action on the part of the court. The election to be held next Tuesday is an uncontested election. My understanding, there is no candidate in the opposing party. It's not as if the plaintiff in this case is the opposing candidate. She is not. So we believe the more appropriate step here would be for this matter to be placed on some type of a reasonable schedule, and that a date perhaps be set for a hearing at a future time, a more appropriate time, when certainly we've had an opportunity to be prepared. From outer appearances, it looks like the plaintiff has been preparing for this for some time. I notice the press is here and notified. Numerous pleadings have been filed, and we respect the request and opportunity to be prepared for hearing as well. Mr. Clay?
Your Honor, we object to any continuance of this proceeding. Mr. Jones was served on Friday. He had an opportunity to secure counsel. We tried to get him on the phone to give him notice of this hearing at the time it was scheduled by the court. There are actually two separate considerations here. The court can enter an order prior to the general election and can order certain things to be done as far as removing Mr. Jones from the ballot. Waiting until after the election occurs would certainly be prejudicial not only to the plaintiff in this case, but to the voters and residents of Spencer County.
And in what way? How is that prejudicial if the hearing was held after next Tuesday? You've
Because-
preserved your right.
Sir?
You've preserved the right to challenge the bona fides at this point. And the case law is very clear on that, that once it's filed prior to the election, then it has been preserved for review.
I agree that the court can take action, but there are two separate things the court can do, as I understand it. The court can order that the votes that are cast for Mr. Jones, if any, in the general election, not be counted. They can be disregarded.
And can that not be accomplished after the election is over?
I do not believe that can happen after the election's over, but
If he's not qualified, even after the election, the votes will then be void.
let me ask Mr. Lay to respond to that, because he's really been hitting the books on that, and I think he's much better prepared to answer that inquiry perhaps than I am, because I've been working on the facts more.
Yes, sir.
Judge Keith Lay, co-counsel for the plaintiff in this case. You're absolutely right, there are two options. One is to, if an order is entered before the general election, is that a name can be, a candidate can be removed from the ballot. The effect of then doing an order after the general election is had is not that the votes themselves are void, it's that the election is deemed not to have happened.
Correct.
And that is.
So the effect is the same.
But, and factually, it's not, factually, I believe the representations by opposing counsel were not correct. Ms. Holland is a write-in candidate on the ballot on Tuesday. And so it's not that it's an uncontested election.
She's a write-in candidate, but that's an opposite to the statute as well. Correct?
Not to my knowledge, Your Honor.
Isn't there a statute that prohibits someone that is defeated in the primary election from then asserting a position on the ballot as a write-in?
It's in the city regs.
Your Honor, in fact, I think what you're referring to is 118-345. It says, "No candidate who has been defeated for the nomination for any office in a primary election shall have his name placed on voting machines in the succeeding regular election as a candidate for the same office for the nomination, which is a candidate in the primary election." I think that may be the statute, but that doesn't refer to write-ins, but you may be referring to a write-in statute as well. I'm not sure.
And that's trying to recall from
She's
15
certainly
years
not
ago.
entitled to be on the ballot, and I don't think she is on the ballot.
Mhm.
But again,
Well,
I
and
think
here, let me pose this question to you, Mr. Lay. If the hearing is not had today, and I'm saying what if, all right, this is a big what if. Hypothetically, if Mr. Jones was disqualified, where does that leave the election?
If the hearing is held today, or
No,
if the hearing is not.
if it's held next week or in 2 weeks.
If he's disqualified after the election occurs, my understanding of the law is that the election is deemed not to have occurred.
Correct.
And then I believe after January 5th, a county attorney would have to be appointed. And then Spencer
Special
County would have to
election.
go to the expense and the trouble of having a special election.
Right, right. So, my question is, how does that prejudice?
Judge, just the fact that it would, I think it would be a better solution is if we could have the hearings today in order to, if he's disqualified, remove him from the ballot, allow the election to proceed, rather than to go to the expense and the trouble of having a general election, county attorney appointed to take office January 5th.
I would disagree with that position. I think that the sacredness of the ballot box has got to be the paramount concern of any court in any democracy. And to say that it would be prejudicial to the plaintiff at this point, I think is not accurate, in that the remedy is still available to the plaintiff, whether the hearing is held today or whether it is held next week, because the law has been certified by the Kentucky Supreme Court that the issue has been preserved. There is no waiver of the right to bring the claim of Mr. Jones' qualifications. If it turns out that the plaintiff succeeds in the cause of action, then the appropriate step would be, as you said, the election would not have deemed to have been taken place, and then the process of the constitutional safeguards under the Kentucky Constitution, as well as the election statutes would then kick in at that point. Those things are put there for a reason, and I believe that, you know, this is such an important issue to the voters of Spencer County that we don't hastily have a hearing wherein it's been, what, 24 hours, Mr. True?
Correct, at most.
And to be honest with you, that was unsettling to me, to come to court today to be prepared on whether or not such an important question of whether or not this election should go forward or not be handled where a party has not been, you know, apprised of, you know, at least, and from a discovery standpoint as well. That puts the court at a disadvantage as well. I believe that discovery, and I believe that there has been a discovery request and a tendered proposed order, that be shortened to 10 days for those documents to be produced. And that's on your all's motion. So I think that goes against the argument of let's have an expedited hearing, but yet we want our discovery as well. Mr. True, I'm going to sustain your motion, and we will have the 10 days as proposed, Mr. Clay, as far as the discovery items are concerned. And I'm going to sustain that motion and enter that order that the respondent, Mr. Jones, has 10 days from the entry of this order in which to respond to those requests for production of documents. That order will be entered. The evidentiary hearing will need to be set. And let's see. So 10 days from today is going to be, that will be the 7th of November, so we're looking at do you have a calendar there? Okay, the week of the 10th. Okay. That's what I forgot about that. Okay, that Wednesday. No. Yes. Right. So that is in the morning, and then that's the military guy coming from overseas. Okay. Is 2:30 just the normal time that they set those? Okay. Why don't we see if we can reserve or move there to late in the morning. And then that will leave the afternoon for Spencer County. Okay. Well, if not, we would have to, I'll just have to do it late in the afternoon. No, but it's right in the middle. They're gonna need more time. So. Yeah, that's gonna take. One. Okay. All right, thanks. Okay, the only day that I have is the 19th of November at 1 o'clock. And I'm moving a couple of things to have the afternoon set aside. So the 19th at 1 o'clock, we'll have our evidentiary hearing, and that should give time for the discovery to take place. And then we will reconvene at 1 o'clock on the 19th of November. Anything else today?
Nothing else,
The order is entered on the discovery. All right. Thank you very much for your record.